You know, anytime you make a deal, whether you're buying a concert ticket or signing a business agreement, you're making a promise. But what happens when the world just throws a massive curveball and that promise becomes literally impossible to keep? Well, that's what we're diving into today, a really fascinating legal concept that's built for exactly those moments.
So let's imagine this. You've booked your absolute favorite band for a huge event. The contract is signed, the tickets are flying off the shelves, and then, a week before the show, the venue burns to the ground. Gone. The entire heart of the agreement just vanished. So, is that contract still on? What in the world happens now?
Well, thankfully, the law has an answer for this kind of chaos. You can think of it as a built-in escape hatch for contracts. It's designed specifically for when some crazy, unforeseen event comes along and makes the original plan totally, completely impossible.
And it has a name, the Doctrine of Frustration. Here in India, you'll find it under Section 56 of the Contract Act. Basically, this doctrine is like a legal safety valve. If a completely unexpected event makes a contract impossible to perform, the contract just ends. It becomes void. It's the law's way of saying, hey, we're not going to hold you to a promise that through no fault of your own, you literally can't keep anymore.
And this whole idea isn't new at all. It's built on a really old Latin principle that basically says the law won't force you to do the impossible. It's just common sense, right? This idea of fairness is the absolute bedrock of the whole doctrine.
But, and this is a huge but, this is not some magical get-out-of-jail-free card for any contract that becomes inconvenient. Oh no, the bar for this is incredibly high. Courts use a really strict four-part test to figure out if a contract is truly, genuinely frustrated.
For a contract to be frustrated, all four of these conditions have to be met, no exceptions. First, the event has to be something nobody saw coming. Second, it has to cause such a radical change that the whole foundation of the agreement is gone. Third, and this is a big one, it can't be anyone's fault. And finally, performance has to become genuinely impossible, not just a bit harder or more expensive. Let's see how this actually works with some real cases.
Okay, so that's the theory. But what does this look like in the real world? These landmark court cases are going to show us exactly how judges apply those four crucial tests.
This first one, Taylor v. Caldwell, should sound pretty familiar. A contract was signed to rent a music hall for some concerts, but before they could happen, the hall burned down. The court said, yep, the contract is frustrated. Why? Because the very thing they made the deal about, the music hall itself, was gone. It ceased to exist. Performance became physically impossible. That's a textbook case.
But impossibility isn't always about something being physically destroyed. Check out this key Indian Supreme Court case. A deal was made to sell some land. But before the sale was final, the government stepped in and took over the land for military use during a war. All of a sudden, it was legally impossible for the owner to sell. The contract was frustrated by a government order.
And it can even apply to people. In Robinson v. Davidson, a famous pianist was booked for her performance, but she became too sick to play. The court agreed the contract was frustrated. The whole point of the contract was for her specific, unique talent. Her illness made the performance impossible, so the contract was dissolved.
Okay, so we've seen when it works, but it is just as crucial, if not more so, to understand when this doctrine doesn't apply. This is where a lot of people get it wrong, and the courts have been super clear about its limits.
Right. Here's the absolute key distinction. There's a huge difference between something being impossible and something just being a bad deal. If a contract suddenly becomes way more expensive or difficult, or you're not going to make a profit, well, that's too bad. That's just business risk. The law won't let you out of a contract just because it became a bad bargain. For frustration to apply, performance has to be objectively impossible, not just financially painful.
Now, you might be thinking, hey, isn't this just a force majeure clause? That's a super common question, but they're very different. Think of it this way. Frustration is the law's automatic backup plan. It kicks in by itself when something totally unforeseen happens. A force majeure clause, on the other hand, is the backup plan you write into the contract yourself, listing out specific events like floods, wars, or strikes that will excuse performance. One is a safety net provided by the law, the other is a tool you have to negotiate.
And finally, there are a few other clear no-goes. You can't cause the problem yourself. That's called self-induced frustration. It also won't work if the event was something you really should have seen coming. And, this is an interesting one for Indian law, it generally doesn't apply to property leases. Those are typically handled by a completely different law.
All right, so let's pull all of this together. When you strip away all the legal jargon, what's the big idea here? It really comes down to a simple concept: fairness.
So, here's what to remember. First, just think of frustration as the law's reset button for contracts that have become impossible. Second, and I can't say this enough, the standard is sky high. This is for true objective impossibility, not just a business deal that went south. And finally, the whole purpose of this is to make sure the outcome is fair when some random event, totally outside of anyone's control, makes the entire point of the contract meaningless.
At the end of the day, this doctrine really shows us how the law tries to balance the need for solid promises with the reality of an unpredictable world. And it leaves us with a really important question to think about. In a world that's always changing, how can we write agreements that aren't just solid, but are also resilient and fair enough to handle the truly unexpected?